You have to have reasonable, articulable suspicion of a crime.
You're on private property looking at people's
Again,
windows.
if you cause
No,
a
this is
disturbance,
public. This is public
if
property.
you cause a disturbance,
This is
then
public
you can
property.
be charged with disorderly conduct.
Were you parking your cop cars back there?
As long as
Then
you're
it's public.
civil, as
It's
long
public.
as you're civil, there's not a problem.
I'm civil, brother.
That's what I'm saying. But if it did become disorderly, then you could be charged with disorderly conduct.
Yeah.
But until then,
Don't-
as long as you're
You
civil,
were also looking at private
everything's
vehicles
good.
back there too, because we.
I can look at anything I can see from public. You can't trespass my eyes.
It's private property back
That's
there.
public.
Other
If
than
you
police
park your cars
there.
back there, that's public.
The other cars are not
And
public.
even if it was private, I have to be trespassed before I've committed a crime. So no one in here knows what the hell they're talking about. This is getting crazy.
Mr. McHenry argues that the parking lot is public property because the officers park their vehicles there, and that even if it is private property, he has to be trespassed before he can be considered to have committed a crime. Although the government's lease on private property gives it the right to use the property according to the terms of the lease, actual ownership does not transfer, and the property will remain privately owned. Nonetheless, the nature of its use by the government can impose certain obligations, regulations, and access rights that might not otherwise apply to purely private property. For instance, if the property is used for public services, certain areas might be accessible to the public, despite the fact that the underlying ownership remains private.